So let's talk about the first major law passed constitutional amendments that affects employment, and that is Title VII of the Civil Rights Act. Title VII of the Civil Rights Act actually has a fair amount of sections, and each one really establishes a major chunk of kind of the modern view on federal legislation on employment decision making. So the first section prohibits discrimination in employment. Now, discrimination, though, is specifically defined as protected groups. Now, the protected groups are not specifically listed. They're listed by type. So race, color, religion, origin, and sex. Now, some of that, of course, has now resulted in a fair amount of discussion. So race and color basically means ethnicity, as we often define it today, but that doesn't mean that you have to be in the minority or majority, simply that a decision was made about you that was made more about your ethnicity than about your actual work performance. Your religious affiliation, your national origin, and finally sex, which generally has been defined as binary gender. It affects all aspects of the employment relationship. So basically it does include wording and specific mentions of pretty much any decision making from recruitment, first contact with an organization, all the way through performance appraisal, through decisions and who gets training and what type of training is being assessed, and all the way up to termination as well, in addition to promotion. Now there is some caveats in there. One, the Civil Rights Act does allow certain organizations to give preference to veterans, and there's an exemption that anytime it has anything to do with national security, the federal government has the right to ignore Title VII of the Civil Rights Act, but they do have to defend it with basically a national security reason. Additionally, Title VII created a specific enforcement arm of the executive branch, the EEOC. And the EEOC's job is to both provide guidance to organizations, to come in when requested to examine situations in organizations, but they can also initiate their own investigations of organizations if they think those organizations are in violation of Title VII of the Civil Rights Act and any additional laws that have been passed since then based on the same kind of criteria, usually just adding additional protected groups. So let's look at the Equal Employment Opportunity Commission. Definitely, I think it's worthwhile to go to their website and really get a good feel for what they are. The actual commission itself is 5 individuals appointed by the president and confirmed by Senate. However, under those 5 individuals is a fairly large regulatory enforcement body. They have 50 field offices throughout the 50 states, 24 districts offices, and approximately 2,800 to 3,500 employees depending on the year. It is an independent regulatory agency. It enforces employment law. And its functions basically break down into 3 kind of informations. 1 is the compliant process, and I'll come back to that one. 2 is issue regulations. Now again, a regulation isn't a law. A regulation is basically information about how organizations can comply with the law. They also gather information about how well the successful or organizations are being successful at complying with the law. So they gather data. The EEO-1 form, which basically a lot of times a lot of state agencies will use and federal agencies when employing people, is a disclosure of protected status. So that the EEOC can be kind of tracking employment processes that might be in violation of the laws that it enforces. Now, the complaint process is a little bit more detailed, and I want to get into that briefly because there's effectively kind of 3 levels: investigation, conciliation, a consent decree, and litigation. So investigation is the first step. That's the EEOC looking to see, is there evidence? Kind of think about this as police officers gathering information. Do we think there's enough evidence to bring this to a prosecutor? Do we think that this violates the law? Now, these investigations can be actually initiated by the EEOC itself, but more likely than not, they're going to be initiated by a complainant who basically is saying, I was wronged and I think the law has been violated. Now, a little bit of a caveat to that. If you are someone in a protected group who thinks that a decision has been made in an organization based on your group status and not your performance, you could, of course, ask the EEOC to initiate an investigation. If they do so, you can leave that investigation for a civil lawsuit at any point if you so wish, But also, the EEOC may not start an investigation, and that does not limit you from looking for civil discourse or civil remedy. In other words, I want to make it very clear that the EEOC is functioning as a regulatory agency that actually investigates and potentially interacts on violations of the law. So that's kind of criminal law, even though it's employment law. However, there is also civil law. You can sue an organization for wrong treatment, that you were treated unfairly, and that can be both integrated into a process with the EEOC or separate. They're not dependent on each other. They're not connected. So if the EEOC does not take your case, that doesn't mean that you don't have the ability to try a different way. Now, I would like to note that in reality, it is often very hard to win a civil case against an organization, especially when the EEOC has already basically said they're not doing an investigation. But it is still a possibility. Most investigations by the EEOC will not actually result in an actual court trial or litigation. What it will do is a consent decree conciliation. In other words, what the EEOC usually works for is they basically say if they think there's evidence that the law was violated, they will talk to both the complainants, the people that were violated or had their rights basically not supported by an organizational decision. They'll work with the organization and they'll try to come up with basically a fix. Get both parties to agree to the consent to fix the situation, make sure it doesn't happen before, and to basically fix whatever was the problem. So if someone wasn't promoted that thought that they should, thought that they weren't being promoted because they were of their protected status in one of those categories, the EEOC agrees, finds evidence, the organization agrees and says we're going to do the following things to fix our system, and of course we're going to promote this person. Both sides agree, a consent decree is signed, and that's where it would end. Now, not always. The EEOC may choose to move past this and go straight to litigation, and that is where they actually serve as effectively prosecutors, prosecuting the organization for its violation of the law. The EEOC also created the Uniform Guidelines and Employee Selection in 1978 and have continued to update this document up to this day. It was developed by both the EEOC and other regulatory agencies, and it's basically lists the characteristics of acceptable selection procedures. Not law, but given great deference. And within this guideline is also where the legal definitions of adverse impact versus disparate impact exist. And disparate impact often sometimes is going to be referred to as disparate treatment as well. So let me talk about this briefly. So the first thing is that you should become very familiar with the Uniform Guidelines and Employee Selection. If anyone is going to be involved in any type of organizational decision making as an IO psychologist, this is one of the things you need to make sure that you are following, that you're complying. Because if there's ever a challenge to an organizational decision, whether it is hiring, whether it's promotion, or whether it's termination, one of the things the judge is going to want to know is, did you follow the Uniform Guidelines? And if you didn't, you're in a much more shaky position to defend that decision. Now, as far as adverse impact versus disparate treatment or disparate impact, adverse impact basically refers to a system or a decision-making structure, an intervention, a process, a series of assessments, however the decisions are being made in the organization, have resulted in an adverse impact on a protected group. But that impact was not intentional. Now, intention is 9/10 of the law, honestly. It's not possession, it's intention. Most of the time when we're talking about laws, some of it is it intentional or unintentional? And that is often an argument that's going to be made. And intention is hard to prove in a court of law. Now, intention probably doesn't matter much when someone gets killed, but intention does matter in the way the Civil Rights Act and Title VII is written and the way the courts have ruled on it. So adverse impact is basically intentionless. It basically means that there has been a violation of the law. It wasn't intentional. There is no smoking gun that the organization designed this structure to basically disadvantage a group of people. And usually adverse impact cases often will result in, again, a consent decree. Basically, the organization will agree to change its systems and maybe do some recompense to the people that have been affected. Now, it is also worth noting that adverse impact cases have limits on damages. So if you're trying to show adverse impact in a civil case, you're only going to basically be able to get lawyer fees and maybe past due salary. You're not going to be able to come after the organization for damages. Which, by the way, is what most lawyers are wanting. Lawyers want to go after organizations where they can go after damages, because damages are then a major part of what they make as far as profit. Disparate impact or disparate treatment means not only was a protected group treated unfairly, it was intentional. And if you can show intention, if you can find the smoking gun where a CEO of a company said, I want you to use this selection procedure because it is less likely that we'll then hire insert protected group, then you can go for disparate treatment. That is probably going to end in legislation, or not legislation, it's going to end in actually litigation. It is probably not going to result in a consent decree. And now you're not only looking at fixing the situation, you're also looking at bringing large financial damages against the company. The reason to also keep this in mind is if you ever run across a legal case, and the one that sticks in my mind the most fairly recently was the Walmart case, where the data pretty much showed unequivocally that if you were a woman in any of the Walmarts across the United States, your chances of being promoted were significantly less than if you were a male. Your chances of getting extra hours was less. Your chances of getting the jobs that required management skills were less. Your chances of ever being promoted were less. This was found across the company. Walmart, however, was found not guilty. And a lot of people are like, how did this happen? And I've seen some stories that basically claim the courts just basically said Walmart was too big to fail. That is not completely accurate. The lawyers in that case were not trying to show adverse impact, which was almost unquestionable. They were trying to show purposeful intent, disparate treatment, to then fine Walmart millions, if not billions of dollars for this. And that's what the courts actually found was not proven. They did not find that smoking gun according to the courts. They didn't prove disparate treatment. And if you go for disparate treatment, you can't then back down to adverse impact. The court is going to look at it one way or the other. You're either doing an adverse impact case or a disparate treatment case. So adverse or disparate impact, both of them require a little bit of statistical analysis prior to usually the EEOC moving forward. So both have the same standard, it's just whether or not there was intent. So again, adverse impact is unintentional discrimination. Disparate treatment is the same discrimination, but with intent. And what generally the courts have ruled is what they're looking for is a 4/5 or 80% rule. And what this means is that the selection rates for minorities must be at least 80% of the selection rate for non-minorities in order for you to be in compliance with the law. So basically, this is dependent on your samples as well. So what we look at is the percentage of selections for a majority person. For example, if the person that's actually making the challenge against the organization, let's go with Walmart, women are claiming that they are being treated differently, that they're experiencing adverse or disparate impact. The first thing the organization is going to look, or first thing EEOC is going to look at, is they're going to go, okay, how many men applied to be hired in the last year? Whatever that number is, what percentage were hired? That's the first percentage. We're then going to look at how many women applied at the same time and what percentage of women were hired. If that percentage of women hired is within 80% of the percentage of men hired, there is not evidence of adverse or disparate impact. If there is a greater than 80% difference, then there is potential evidence of adverse or disparate impact, and the court is going to be able to proceed on looking at this. So this is kind of the first bar that almost any of these cases go through. Now notice this is a statistical bar, and this is a statistical bar that requires a fairly large amount of data. You need to have an organization that's hiring a lot of people to be able to look reliably at these numbers. So that's also something to kind of keep in mind, that these rules are made for larger organizations. And a lot of times smaller organizations are able to fight off this kind of initial ruling by simply going, yeah, we had 5 people apply from the majority group and 3 people apply from the minority group. We did hire 3 of the 5 from the majority group and none from the minority group, but the minority group was quantifiably less skilled for the job. The job itself, for instance, required a college degree and none of them had it. Now, that doesn't mean that you can't continue challenging that. You might challenge whether or not a college degree is really needed for that job. But I'm just saying that usually the first bar you're going to have to cover or cross or hurdle over to move forward on an adverse versus disparate impact phase is the 4/5 rule. So again, to calculate this, the impact statistics, we simply calculate the selection rate for each protected class separately. Usually what's going to drive this is whichever group a person is using or a group of people are using as a potential violation of Title VII. So if it is a group that is based on religion, you would then divide your population that are applying for your job or are being promoted or are being terminated, and then look at each religious group, majority versus minority. And again, the minority versus majority is not tied to social levels or worldwide level or United States levels of minority versus majority. It simply refers to differences between the class rates. So for example, if you've got a company where the majority of people within the organization are women, then they would be the majority group, and then men would be the minority group. But even then, majority versus minority is kind of a non-starter, because if you found a difference between the minority, so the minority is being hired more often, that's still a potential adverse impact. It's simply any group that's a protected group, whether they're the majority or the minority, if they are being hired at a lower rate than 80% than another group, you have a potential violation of Title VII. So the selection rate is simply the number of hired divided by the number of applicant. That gives us our percentage. And then we look at whatever is the group that is more favorably treated. That basically becomes the majority group, even if they're in the minority. So it's more about favorably treated versus unfavorably treated. So for example, if 70% of whites were selected, and then 56% of minorities must be selected as well to eliminate adverse impact. So again, 80% of 70 is 56. So if my selection rate of whites is 70% and my selection rate of African Americans was less than 56%, I have initial statistical evidence of adverse impact or disparate treatment. However, if 70% of whites are selected and 57% of African Americans are selected, I have not reached that initial bar. Now, that still may be the result of a problem. That still may be an issue the organization may want to look at, but it's no longer a legal definition or a legal, if you will, flag that the organization, that EEOC is going to continue to look at the relationship. And you do need to compute this for each and every hurdle of a selection system or each and every hurdle in a promotion system. So if you have 5 different assessments, you have to look at all 5 assessments individually and then the end result of the entire selection process. And if there's adverse impact, a breaking of the 4/5 rule anywhere, it is potentially something that could be moved forward in a legal case. So what if there is adverse impact? Step 1 is to eliminate it. And that may seem very simplistic, but a lot of times it may be that there is a selection tool or decision making that shouldn't be used in the first place, and that simply removing that process may actually get rid of the adverse impact. Another possibility is to replace it with a procedure that has less adverse impact. So for instance, if there's a particular requirement for the job that certain majority group members or more favored group members have access to, statistically more likely than a minority or a less favored group is, then is that actually job relevant, or could we simply remove it or lower it? So for example, are we requiring a college education for a job that easily could be done with someone with a high school education? Or are we using a particular assessment test that tends to favor a group over another? Is there a similar test that would also still predict performance that has less difference between protected groups? So again, an organization has 3 options here. The first one is to simply eliminate the system completely. The second one is to replace it with a procedure that has less likelihood to cause adverse impact. The third one is to defend it. And that is possible, and many organizations have done it. In other words, you have to demonstrate that it is job relevant. That yes, this particular selection procedure does cause disparate impact, adverse impact. It does violate the 4/5 rule. But the measure itself, the process that's being used, is so well tied to actual job performance, and that there is not a better test out there that is less likely to cause adverse impact, that the organization is justified in still using this. And this often becomes a very complex case of validation, bona fide occupational qualifications. In other words, you have to show that what you're actually measuring is reasonably necessary to business operations, and that the decisions you're making are a business necessity. In other words, if you tried to move your organization into a more diverse model, you would actually result in a negative effect on the business, either its efficiency or its safety. So an example of a bona fide occupational qualification, and there's a few of them out there actually where various organizations have defended a 4/5 rule violation with this option. Specifically, the one that I always jump to mind is actually the Hooters chain. Down in Florida, a fairly overweight male sued to become a Hooters girl. And basically, I love this case because at some point, if you read through all of the court hearings, Hooters admits that people don't eat there for the food. It's actually in a court document that they basically say that the reason their company is successful and the reason people come and spend money at their business is because of a bona fide occupational qualification, and that is young, relatively attractive females being the main primary servers at that restaurant. So they actually were able to fend off a 4/5 violation, and in fact it was an extreme 4/5 violation, as men are simply not hired for that role, period, by showing it was tied to their business model, and that if they actually changed their business model, their business itself would be less efficient. So here's just an example of an adverse impact. So again, we have males versus females in the written test. 200 males took it, 130 passed, which meant basically 65% were passing. Now we then take that 0.65%, we actually multiply it by 0.8, the 4/5 rule, to get basically our adverse impact number, 0.52. So if women are below 0.52 in selection on this test, the test is causing adverse impact. And in this case, indeed, it is. 125 women took the test, only 60 passed, that's 0.48. So it's below the 0.52, it is adverse impact. Performance tests, men, 73% passed, and again, 4/5 of that was 0.58, and again, women, 0.53. And at that point, again, that is a violation of the 4/5 rule. Now, as we move forward onto the oral board, we actually find that women are doing better. So if we were actually comparing this, we would actually need to figure out the adverse impact based on the women's percentage of 0.88. In this case, that's 0.64, and men are well above that. So there was not adverse impact against men on the last test. So we have adverse impact on the written test, adverse impact on the performance test, and therefore an organization might be brought forth for either conciliation, a consent decree, or the EEOC may choose to move forward on litigation. And again, the organization could then say either A, we're going to eliminate it. We're going to get rid of written and performance tests and simply use the oral board. They could change it. They could put in a new written test and a new performance test, which has been found in past studies to actually be less likely to adversely affect women. Or they could argue this written test and this performance test is tied to organizational success, bona fide occupational qualification, and there isn't anything better out there, and it's just simply showing that for whatever reason, men are actually better at this job than women. Now again, a lot of organizations tend to shy away from this because that is, it may be legally correct. It usually doesn't play well in the press, and it usually doesn't play well with their customer base to take on this thing. But again, we're not talking about the social ramifications of what is right or wrong socially or morally. We're talking about what's right or wrong legally and the process of that legal challenge. And again, disparate treatment simply adds intentional. And if you can show intentional discrimination, if you can find that smoking gun, if you can find the CEO sent out a memo, I want you to use this because it will keep defended group out of my organization, then not only can you actually get an organization to have to fix their methods, you can also sue for fairly large amounts of damages. And that's why a lot of times employment cases will try for disparate treatment when there's clearly adverse impact, and often fall a little short. It's a hard bar to show true intentional discrimination. What are the discrimination consequences? The big one's litigation, especially if you're found to be in violation of disparate treatment. That's big money, long and time-consuming process. Suspension of government contracts. Most government contracts include that you are following Title VII and all other employment law. If you lose an adverse impact case, depending on the size of it, you may be responsible for back pay to an entire class of discriminants. And beyond the legal ramifications, there's also the professional image impacted. Difficulties recruiting, tenure difficulties keeping people, it can be a big mess. Now, the reality of this situation, though, again, I like to be kind of blunt with this. It is fairly rare for an organization to lose a big discrimination consequences case. There are a fair amount of cases every year. Most of them result in a fairly small amount of legal time. Most of them result in a consent decree. And most of them involve kind of keeping it off the front page of the newspapers. However, organizations are, I would say, a little hyper aware about not being in this situation. So they're more about preventative than necessarily defense, and it's one of the areas where, again, IO psychology has become a very big part of the employment, especially HR processes, because organizations look at it as kind of insurance that I've got someone that can be looking at these procedures, be able to understand the statistics, and even kind of self-audit for 4/5 violations to make sure that we don't run afoul of this process. And again, I'm just highlighting those last 3 points because really those are the big ones. If you actually look at the likelihood of an organization losing government contracts, the likelihood of having to make a major payout either to an entire class of discriminants or even actually a disparate impact case where you have to pay enormous amounts of money in damages, these are very rare. However, the professional image and recruitment difficulties and tenure difficulties, those occur whether you win the case or not. And several large organizations have successfully won cases in employment law under discrimination. In other words, they've defended adverse impact charges. However, the hit then is not a suspension of government contracts or pay. It's a hit in the professional image, how the world looks at those organizations. I'm not sure if you are necessarily aware of Walmart's case, but Walmart pretty much now has had for about 15 years now a reputation of not being a great place for women to work. So even though they won the case, an argument can be made they kind of lost the war.